Hello guys, welcome back to our channel Legal Nexus. ഇന്ന് നമ്മൾ ഡിസ്കസ് ചെയ്യാൻ പോകുന്നത് ജനറൽ എക്സെപ്ഷൻ ആണ്. കഴിഞ്ഞ രണ്ട് പാർട്ടുകളിലായി നമ്മൾ 7 ജനറൽ എക്സെപ്ഷൻസ് പഠിച്ചതാണ്. ഇന്ന് നമുക്ക് ബാക്കി കൂടി നോക്കാം. Section 25 to 13 of the Bharatiya Nyaya Sanhita deals with the defense of consent. By virtue of Section 25 of Sanhita, an act done by a person is not an offence if the following conditions are satisfied. He should not have intent to cause or grievous hurt. The person to whom hurt is caused should have expressly or impliedly consented to suffer harm or to take the risk of any harm. The person consented to take the risk should be above 18 years of age. Section 25 to 30 വരെയുള്ള സെക്ഷൻസിലാണ് കൺസെന്റിനെ കുറിച്ച് പറയുന്നത്. കൺസെന്റ് എക്സ്പ്രസ്ലി ഓർ ഇംപ്ലൈഡ്ലി ആവാം. കൺസെന്റ് എന്നുകൊണ്ട് ഉദ്ദേശിക്കുന്ന ഒരു വ്യക്തി സ്വയമേവ ഒരു ഹാം സഫർ ചെയ്യാമെന്ന് എക്സ്പ്രസ്ലി ഓർ ഇംപ്ലൈഡ്ലി സമ്മതിക്കുന്നതിനാണ് കൺസെന്റ് എന്നതുകൊണ്ട് ഉദ്ദേശിക്കുന്നത്. ഈ കൺസെന്റ് കൊടുക്കുന്ന വ്യക്തി 18 ഇയേഴ്സിന് എബോവ് ആയിരിക്കണം. കുറച്ച് എക്സാമ്പിൾസോടെ നോക്കുകയാണെങ്കിൽ A and Z agreed to fence with each other for amusement. A hurt Z while playing fairly. A commits no offence. It is because both of them had impliedly consented to suffer any harm which may be caused without foul play in the course of such fencing. Section 25 protects person engaged in the ordinary games such as fencing, boxing, football, cricket and the like. The game should be played fairly. There should not be any foul play. Good faith. Section 13 and 31 of the BNS deals with good faith. Good faith act honestly with due care and attention. It protects a person from criminal liability when they act without bad intention and with proper care. Key points. Honestly alone is not enough. The person must take reasonable precautions. If you act carelessly or negligently, you cannot claim good faith. Good faith. Section 13-31 ആണ് ഗുഡ് ഫെയ്ത്തിനെ കുറിച്ച് പറയുന്നത്. ഏതെങ്കിലും ഒരു വ്യക്തി ചെയ്യുന്ന എന്തെങ്കിലും ഒരു ആക്ട് ഒരു ഒഫൻസ് കോസ് ചെയ്തു, പക്ഷെ അദ്ദേഹം ഹോണസ്റ്റ്ലി ഗുഡ് ഫെയ്ത്തോട് കൂടിയാണ് അത് ആക്ട് കമ്മിറ്റ് ചെയ്യുന്നതെങ്കിൽ അതൊരു എക്സെപ്ഷൻ ആയിട്ട് കണക്കാക്കുന്നു. ഇതിന് മെയിനായിട്ട് അദ്ദേഹം ഹോണസ്റ്റ്ലി അതുപോലെ തന്നെ ഡ്യൂ കെയർ നെഗ്ലിജൻ്റ് അല്ലാതെ എല്ലാ പ്രിക്കോഷൻസും എടുത്തുകൊണ്ടാണ് ഈ ആക്ട് ചെയ്യുന്നതെങ്കിൽ അത് മാത്രമേ ഇതൊരു എക്സെപ്ഷൻ ആയിട്ട് കണക്കാക്കൂ. ഒരു എക്സാമ്പിൾ നോക്കാം. എ ഡോക്ടർ ചെക്സ് ദ പേഷ്യൻറ്റ് properly give treatment based on test reports but patient dies. Doctor acted honestly, took due care, good faith applies. No criminal liability. Section 31. Act done in good faith. This section protects people who act for the benefit of another person in good faith even if the result later turned out wrong. അടുത്തൊരു എക്സെപ്ഷൻ ആണ് compulsion. By virtue of Section 32 of the Sanhita, when an offence is committed by a person under the following circumstances, he is exempted from criminal liability. There should be threat of instant death of the person who has committed the crime. Fear of hurt or grievous hurt will not be sufficient. Due to the threat of instant death, he should have done the crime. At the time of the threat, there must be reasonable cause of apprehension. Instant death to the person will otherwise be the consequence. He should not have committed the offence of murder or offences against the state punishable by death. He should not have joined a gang of dacoits knowing their character. However, he was seized by a gang of dacoits and forced by threat of instant death to do a thing which is an offence, and if he has done such an offence, he is not liable for the offence. Section 32 of the സംഹിതയാണ് കമ്പൽഷനെ കുറിച്ച് പറയുന്നത്. കമ്പൽഷൻസ് എന്ന് പറയുമ്പോൾ ഒരു വ്യക്തി ഒരു ത്രെറ്റ് ഓഫ് ഇൻസ്റ്റന്റ് ഡെത്തോടനുബന്ധിച്ച് എന്തെങ്കിലും ചെയ്യുന്ന ഒരു ക്രൈമിന് എക്സെപ്ഷനായി കണക്കാക്കുന്നു. ഈ ഒരു എക്സെപ്ഷൻ ഫുള്ളി അല്ല, കാരണം ആ വ്യക്തി ഒരു പക്ഷേ ഒരു ഡെക്കോയ്സിന്റെ ഗ്യാങ്ങിൽ ഉൾപ്പെട്ട വ്യക്തിയാണെങ്കിൽ അതിന് നമ്മൾ ഒരു എക്സെപ്ഷനായി കണക്കാക്കുന്നില്ല. പക്ഷെ അദ്ദേഹം ഈ ഒരു ആക്ട് കമ്മിറ്റ് ചെയ്ത് ഫോഴ്സ് ബൈ ത്രെട്ടോ ഇൻസ്റ്റന്റ് ഡെത്തോ കോസ് ആവും എന്ന് പറയുന്നിട്ടാണെങ്കിൽ അതിനൊരു എക്സെപ്ഷനായി കണക്കാക്കുന്നു. Trifles means negligible wrong or offense of trivial character. There is a well-known maxim, de minimis non correct. The maxim means that the law does not concern with offenses of trivial character. Section 33 of the Sanhita deals with the defense of trifles. By virtue of Section 33, an act is not an offense if the harm is so slight that no person of ordinary sense and temper would complain of such a harm. The defense is available to the accused even though he has intent to inflict such harm. ഇതിനോടനുബന്ധിച്ച് കുറച്ച് കേസിലാണ് നോക്കാം. വിത മനീസ് വേഴ്സസ് യൂസഫ് ഖാൻ. At the end of the heated quarrel, the accused threw a file of papers which caused a scratch to the complainant. The lower court acquitted the accused since the harm is trivial. The Supreme Court confirmed this finding. Narayan versus State of Kerala. In a campaign by Sarovodaya workers to educate people about the evil of alcohol, liquor shops were picked to prevent people from going there. It was held that even though obstruction was caused, as the harm caused is slight, Section 33 would apply. The High Court quashed the prosecution. The final and an important exception are private defense. The primary duty of every state is to protect the life and property of its subjects. It is a sad truism that state force is not available at all circumstances to protect the life and property of an individual. It is therefore the right of private defense is recognized by law. By virtue of right of private defense, an individual can protect his own life and property, so also he can protect the life and property of others. Section 34 to 44 of the Bharatiya Sanhita specify the circumstances in which and the extent to which the right of private defense can be exercised. Section 33 to 44ലാണ് private defense കുറിച്ച് പറയുന്നത്. Rules of right of private defense. An act done in the exercise of right of private defense is not an offense. The right of private defense is available only against an act which is an offense under the Sanhita. The right of private defense is a defensive right and not a punitive or retributive right. The right of private defense is available to a person for defending his own body and the body of other persons. പ്രൈവറ്റ് ഡിഫൻസുമായിട്ട് ബന്ധപ്പെട്ട ഒരു കേസാണ് നുർമിന വേഴ്സസ് സ്റ്റേറ്റ്. The accused was attacked by a number of men armed with various weapons. He snatched away a weapon from the one of them and struck him with the weapon. He died as a result of the injury. The court held that the accused attacked in self-defense of body, although the deceased was unharmed at the time. Rose versus State. A son shot and killed his father under circumstances including the belief that he is cutting throat of his mother. The court held that the accused is not liable for any offense. In Kurian versus State, it was held that in order to make out a case of right of private defense, the accused need not to plead it in specific terms. The court can consider it even if the accused has not taken that plea, if the same is available to considered from the material on record. The right of private defense is available to a person for defending his own property and the property of others. The right of private defense is available against all offenders, including an unsound person, minor, or an intoxicated person. The right of private defense is not available against the acts of public servant done under the color of their office and in good faith. The right can be exercised against them when there is apprehension that their act would result in death or grievous hurt. The right of private defense cannot be exercised when there is time to have recourse to the protection of public servants when there is chance of getting police protection. One cannot exercise right of private defense. The right of private defense shall not extend to the infliction of more harm than necessary for the purpose of defense. The right of private defense of body commences as soon as reasonable apprehension of danger to the body arises, and it continues as long as the apprehension of danger to the body continues. Section 37 പ്രകാരം ഒരു വ്യക്തി ചെയ്യുന്ന ആക്ട് പ്രൈവറ്റ് ഡിഫൻസിന്റെ അണ്ടറിൽ കൊണ്ടുവരില്ല. ഏത് സാഹചര്യത്തിൽ എന്ന് വെച്ചാൽ അദ്ദേഹത്തിന് പോലീസ് പ്രൊട്ടക്ഷൻ ലഭിക്കാം എന്ന സാഹചര്യത്തിൽ അദ്ദേഹം ഒരു ഒഫൻസ് കമ്മിറ്റ് ചെയ്ത് അതിനെ പ്രൈവറ്റ് ഡിഫൻസിന്റെ അണ്ടറിൽ കൊണ്ടുവരാൻ ഒരിക്കലും സാധിക്കില്ല. അതുപോലെ തന്നെ അനാവശ്യമായിട്ട് ഒരു ആക്ട് ചെയ്യുന്നു എക്സസ് ആയിട്ടുള്ളൊരു ഫോഴ്സ് ഇൻഫ്ലക്റ്റ് ചെയ്യാൻ പാടില്ല. The right of private defense of the body can be extended to causing of death of assailant or offender under the following circumstances: if the assault of the assailant or offender caused reasonable apprehension of death, or if the assault of the assailant or offender caused reasonable apprehension of grievous hurt, if the assault of the offender is with intention of committing rape, or if the assault of offender is with intention of gratifying unnatural lust, or if the assault of offender is with the intention of kidnapping or abduction, or if the assault of the offender is with the intention of wrongfully confining a person, and if that causes reasonable apprehension that he will be unable to have recourse to the public authorities for his release. അടുത്തതായി നമുക്ക് പ്രൈവറ്റ് ഡിഫൻസ് ഓഫ് പ്രോപ്പർട്ടി നോക്കാം. The right of private defense of property is available against any of the following offences or an attempt to commit such an offence: theft, robbery, mischief, criminal trespass. The right of private defense of property can be extended to causing of death of offender under the following circumstances: if he commit to or attempt to commit robbery, if he commits or attempt to commit house breaking by night, if he commits or attempt to commit mischief by fire or by building any building, tent or vessel which is used as a human dwelling or as a place for storing of property, if he commits theft, mischief or house trespass under such circumstances as may reasonably cause apprehension that death or grievous hurt will be the consequences if such right of private defense is not exercised. In conclusion, the general exception under the BNS from the backbone of criminal liability. These provision helps the court decide when an act, though seemingly an offence, should not be punished because the circumstances justify excuses or legal protection in the conduct, whether it is act done without intention under mistake by a child, by a person of unsound mind, or done in good faith for the welfare of others. These exceptions ensure that justice is not mechanical but human. They reflect the principle that criminal law must punish only those who act with guilty intent, not those who are protected by law due to special circumstances. Understanding this exception is essential for students, practitioners, and anyone who wants to know how the criminal justice system balances law with fairness, intention with action, and justice with humanity. Thank you for watching this video. If you found this video helpful, don't forget to like, share, and subscribe for more legal insights.